Well, today at 2:31 p.m. exactly, the White House posted on social media, congestion pricing is dead, Manhattan and all of New York is saved, long live the king, President Donald J. Trump. And I'm sparing you what was attached underneath those utterly insane words. It was a deeply perverse rendition of Donald Trump on what was designed to appear to be a fake Time magazine cover with him wearing a gold crown that he imagines kings wear every day. There was a time when New York City was governed by the King of England, but the people living in New York City and the other colonies joined together to kill as many British soldiers as necessary to remove a king from their lives forever. Of course, not a single Republican objected to anything about that social media posting today. And although Republicans will constantly tell you that government is best when left to the state and local officials, especially on healthcare issues or education, for example, education should be as local as possible. None of those Republicans objected today about Donald Trump interfering in the most local possible issue, traffic jams. At the beginning of this year, New York City tried something that I, for one, did not think was going to work, and I thought was going to be a lot of political trouble. It was an idea that had been kicking around think tanks and urban planning seminars for at least 40 years that I'm personally aware of. It was talked about in subcommittee hearings in Washington decades and decades ago. But it was the kind of idea that usually scared most politicians. The New York politicians who supported the idea in the state legislature and the ones who supported it in the city got very scared of the idea the closer it came to being a reality. The idea of congestion pricing to try to control traffic in Manhattan. So they delayed the idea. They delayed the idea, that long-held dream of urban planners, congestion pricing, in effect, electronic tolls invisibly applied to cars venturing below 60th Street in Manhattan. It was a desperate attempt to try to do something about 100 years of increasingly unbearable New York City traffic. And as the deadline for implementing congestion pricing approached, politicians began to fear the wrath of every New York City car driver, while the governor had to worry about the wrath of suburban New York drivers also. Politicians who supported congestion pricing as the implementation day approached worried that they wouldn't get any gratitude at all from most New York City residents who don't even own cars. New York City is the only city in the country where most people do not own cars. And at the last minute, they dramatically reduced the toll pricing in the congestion pricing plan. And the first day that congestion pricing went into effect in New York City, a miracle was upon us. I got into a car in lower Manhattan and speeded up to Midtown on the FDR Drive at the highway speeds that road was designed to allow for the first time in my life. The ride that normally would take at least 45 minutes took 20. I went into an office where the first person I spoke to was from Staten Island. Her commute to Midtown Manhattan usually was at least 90 minutes each way, sometimes 2 hours. And that day, for the first time in her life, it was 45 minutes, and she wasn't even driving. She was riding the express bus from Staten Island, and that's when I realized congestion pricing just might turn out to be the most popular thing that has happened in government in New York City in a very long time, because the bus riders were very happy. New York City roadways intersect with the interstate highway system. So there are three levels of governmental interest involved in congestion pricing: the government of New York City, the government of New York State, and the federal government. Within a couple of days, most people in New York politics breathed a huge sigh of relief, realizing that not only had the plan worked, exactly as intended, even better than intended by breaking gridlock. But it could end up being the most popular thing they've ever done. President Biden signed off on the federal government's okay for New York City's congestion pricing plan last year. And today, 2:31 p.m., Donald Trump announced that the king was ending it all, or trying to end it. Donald Trump revoked the federal approval of congestion pricing, and Governor Hochul announced that New York was rushing into court to try to preserve the only new thing ever devised to reduce traffic in New York City in Donald Trump's entire 78 years of life. The only thing that has actually worked. At a press conference about Donald Trump's attempt to block congestion pricing this afternoon, Governor Hochul was asked a two-part question about two different things.
And what would it take for you to determine that Mayor Eric Adams was no longer able to govern New York City?
I'm ignoring the second part of the question because I said that's another day.
Okay, the first part of the question, which we missed, was actually about congestion pricing. And then there was a question thrown in there about Eric Adams, which the governor then didn't want to answer. The governor then turned to legal experts with help for the questions about congestion pricing and where that case was going to go. Now, it has been falsely reported day in and day out, pretty much everywhere in the news media, that the governor of New York has the power to summarily fire the mayor of New York. That is not true, as I explained here last night, but it bears explaining again, since it's apparently a difficult lesson for people to learn, especially in the news media. The governor of New York only has the power to initiate a process that has never been tried before to remove the mayor of New York only after a hearing in which the mayor would be allowed to defend himself and be represented by as many lawyers as he wants, who would be allowed to call as many witnesses as they want. The rules for such a hearing do not exist. They would have to be created by the governor. Because in this kind of hearing, which has never occurred, the governor plays the role of the judge and therefore would have to be there every minute. The governor also plays the role of the prosecutor in that hearing, presenting the evidence against the governor. And the governor plays the role of the jury in that hearing and would have to make the final fact-finding and render a verdict. Every aspect of that process that has never been used before and has been never tested for due process, every bit of it could be appealed in court. And such appeals could be fought all the way to the United States Supreme Court, and that could take years. So, no, the governor does not have the power to fire the mayor. Just have a hearing about the possibility of removing the mayor. And in that hearing, if the governor decided to have one, she would not be able to use any of the criminal evidence collected by the FBI and presented to a federal grand jury, which led to the criminal indictment of Mayor Eric Adams on bribery and other charges. So there would be zero criminal evidence available to the governor to consider in such a hearing. Zero. And so the magic bullet firing scenario that you've been hearing from people who literally in every real sense don't know what they're talking about is impossible. Also, at exactly 2:31 p.m. today, the Trump White House issued their proclamation from their king about congestion pricing. Exactly 2:31 p.m. And at that very minute, Mayor Eric Adams was testifying under oath for the very first time in the criminal case of United States of America versus Eric Adams. Federal Judge Dale Ho, who has been presiding over the case of the United States of America versus Eric Adams, was hearing a motion by Donald Trump's Justice Department to just dismiss the charges against Mayor Adams, a motion that was opposed by all of the New York City federal prosecutors who were handling the case. In all, 8 federal prosecutors in New York City and Washington have resigned over what they believe is an illegal scheme to dismiss the case for political purposes. One of the briefs filed in the case today included a letter from Danielle Sassoon, who was the acting U.S. attorney for the Southern District of New York, her 8-page letter offering her resignation and her refusal to file the motion to dismiss, accused acting Deputy Attorney General Emile Beauvais of entering a quid pro quo for the dismissal. The letter said, Mr. Beauvais proposes dismissing the charges against Adams in return for his assistance in enforcing the federal immigration laws. The reasons advanced by Mr. Beauvais for dismissing the indictment are not ones I can, in good faith, defend as in the public interest and as consistent with the principles of impartiality and fairness that guide my decision-making. Danielle Sassoon's letter also reveals that she and her team of prosecutors were ready to bring an additional indictment against Mayor Adams, saying, we have proposed a superseding indictment that would add an obstruction conspiracy count based on evidence that Adams destroyed and instructed others to destroy evidence and provide false information to the FBI, and that would add further factual allegations regarding his participation in a fraudulent straw donor scheme. Emile Beauvais could not find any attorney in the Justice Department willing to stand in front of the judge today and argue in support of that motion. We saw the unique spectacle of an acting Deputy Attorney General appearing as a litigator in court, which they virtually never do. One of the prosecutors who quit rather than stand up and tell the judge what he believes to be lies in the courtroom today said in his resignation letter last week that he was confident that Emile Beauvais would be able to find, quote, enough of a fool to do it. Emile Beauvais did it. Emile Beauvais told the judge, I'm here personally to answer your honor's questions, to give you the assurance you need to sign this. Judge Ho began the hearing by asking Eric Adams, under oath, if he was on drugs. That is actually a standard question for defendants in hearings like this to establish that they actually comprehend the proceedings that they are in. The judge clarified that the Trump Justice Department intends to hold out the possibility of bringing these exact charges against Eric Adams against him again whenever they want to. The court, Mr. Beauvais, if and when the motion is granted, can these charges be brought again, Mr. Beauvais? They could be in the department's discretion. Yes, Judge. The court, okay, so Mayor Adams could be re-indicted at a future date. Mr. Beauvais, it's possible. The court, is the government committing to stopping any additional investigative steps with respect to Mayor Adams? Mr. Beauvais, no. That answer contradicts what Emile Beauvais put in writing in his order to Danielle Sassoon to ask for dismissal in the case. In that order, which she refused, Emile Beauvais said, there shall be no further targeting of Mayor Adams or additional investigative steps. Now, you really don't want politicians like Eric Adams to know that the FBI has been ordered not to investigate him. The judge asked Mayor Adams, has anything been promised to you to induce you to consent to the motion? The defendant, not at all, Your Honor. The court, okay. Has anyone threatened you in any way to induce you to consent to the motion? The defendant, no, Your Honor.
If he doesn't come through, I'll be back in New York City, and we won't be sitting on the couch. I'll be in his office, up his butt, saying, where the hell is the agreement we came to?
That video was not part of the record of the hearing today. To Emile Beauvais, the judge said, I just want to confirm my understanding that the motion contains no statement about the government's views regarding the strength of the case in terms of the facts or the legal theory. Mr. Beauvais, that's correct. And less than a minute later, in his very next answer, Emile Beauvais contradicted that answer he had just given when he said he believed that the indictment, quote, is an abuse of the criminal justice process. Emile Beauvais advanced the novel theory that no candidate for office should ever be charged with a crime. He said to the judge, I mean, frankly, I think the fact that Mayor Adams is sitting to my left right now is part of the problem. He's not able to be out running the city and campaigning. I think that is actual interference with the election. So according to the new Trump Justice Department theory, any candidate in any party anywhere in the country cannot be charged with a crime of any kind because that is interference with the election even if the election isn't even that year. Presidential campaigns are 4 years long, remember. Emil Bove also advanced the novel legal theory that you cannot indict the New York City police commissioner because the duties of that job are so important. The judge asked, would a rationale like this ability to govern rationale, potentially apply to other public officials with significant public safety, national security responsibilities here in New York, like the police commissioner, for example? Could it potentially be applicable in the event that the police commissioner were subject to some sort of investigation or prosecution, Mr. Bove? Yes, absolutely. In the long history of police corruption in the city of New York, no one has ever before advanced the theory that the New York City police commissioner cannot be indicted. The last New York City police commissioner to go to prison was Mayor Rudolph Giuliani's police commissioner, Bernard Kerik, who decades later was, of course, pardoned by Donald Trump.